Good morning. Good morning. The Rehabilitation and Social Services Committee will come to order. Will the clerk please open the roll so we can determine we have a quorum?
You have a quorum, Madam Chair.
Thank you. I'm going to take a few things out of order, and the first bill we're going to do is actually Delegate Walker's bill because I have members who have to go to another meeting. So this is House Bill 550, and colleagues, I encourage you to put your attention on House Bill 550. Welcome.
Thank you, Madam Chair. So HB, 550 is before you. What this simply does, this bill would grant adoptees that's 18 years of age or older access to their original birth certificate. Obtaining the original birth certificate is a right by any other adults in Virginia except adopted people. Virginia-born adoptees held the right to their own birth certificate since 1976. Currently, the law, the birth certificates are only sealed when an adoption is finalized and well after the birth parents are out of the picture. They are not sealed when a child is relinquished or when the termination of parental rights documents are signed. Birth parents have no choice or say in what happens with the birth certificate if they choose to relinquish their rights. So in short, that's the bill, but we have folks here. If we have some testimony, I'll be grateful to hear from them.
Thank you, Delegate Walker. I will ask my colleagues if they have any questions.
Okay.
Senator Servo.
Delegate Walker, we done some kind of an assessment to see what the law is in other states to figure out whether we're like outside the norm, in the norm.
I'm sorry, I'm making sure that's what you said.
Do you have a sense of what the law is in other states? Out of all 50 states, how many states grant this kind of access? How many prohibit it? Where we stand relative to other states?
So Virginia's been one of these closed states here. You know, once you become an adult, 18 years of age, this is your original birth certificate. And so
Madam Chair.
What is.
Senator Servo, I think that perhaps you didn't understand the question.
Okay, maybe.
May I repeat it, Senator Servo?
Sure, go ahead.
Yes, go ahead.
The question was, how many other states have the practice that you're suggesting in this bill?
Well over 20 or 30 states that we have reviewed. I left a chart up there with you that may have some of that information if you're going through that. But Virginia is still one of those closed states, and that's all we're asking is that we open up so that people can obtain their birth certificate after they become a legal adult, or legal age, excuse me. This was just recently passed in Louisiana a couple of years ago. The legislator spoke to me about that, and so I think at that time there was 20 or 25 states that had already opened up their records. So some of these states are slowly opening up the records for these individuals that can obtain their birth certificate.
Madam Chair.
Senator Servo.
I just did a quick Google search, and what I've been able to see on Google is that 9 states allow what you're asking for. 19 states have it sealed, and I can't figure out what the answer is in the others. Do you have any better information than that?
If I could ask the records office, okay. Would you mind if somebody who has more experience in this, that has been working on this?
Is this an expert witness?
Yes, she's an expert witness.
Okay, you may come to the
Thank you.
podium.
Thank you very much. I'm a little shorter than him, so let me move this. I'm Rebecca Ricardo. I am the Executive Director for C2 Adopt, a local adoption agency here in Richmond. I'm also an adoptee. I'm also a birth mother. And currently, there is 15 states that have unrestricted access to original birth certificates, Georgia being the 15th that has passed half of their legislative session and is about to pass the second half, as they just had crossover. There are other states that have access to original birth certificates, but with some restrictions. So we don't count them in the same way that this bill is being presented. And there are 2 states that have never sealed original birth certificates, and those are Alaska and Kansas.
Senator Servo.
So, I mean, I'm just, in this article that I'm reading, there's all kinds of different ways states have done this. Some states allow parents to file veto petitions. Some states, I guess have other processes in place. Do you have any sense of how many states provide exactly what you're asking for in this bill?
That was my first answer. So it's 14 right
14.
now. 15 will be happening in about 2 weeks.
Okay.
I have a question. What kind of restrictions have the states that walked a pathway where they're balancing the rights of privacy of the birth parents with the rights of the adoptees to know their natural parents? There must be a balance in here. Can you give us an example?
So Louisiana is probably the best example. They just passed this bill 2 years ago. It's unrestricted access with a contact preference form provided at their state registrar's office that a birth parent can complete the contact preference form that simply indicates if they don't wish to be contacted, should their adult adopted child request their original birth certificate, or it can also state, I would actually love to be contacted, and here's how I would like you to do that.
So may I have a follow-up question? If, in fact, they have that contact preference form, is that honored? If the birth parent indicates that they don't want to be contacted?
To our knowledge, we haven't known anyone to make use of the contact preference form in that particular state yet. How it would be honored would be entirely up to the adult adoptee.
So let me just follow up a little bit here. So the birth certificate would be released with the names of the birth parents on the birth certificate, and it would be up to the adoptee to honor the wishes of the biological parent. Is that what you're saying?
Correct, which is already true for any adult adopted person who chooses to engage in a search of their biological parents. If their biological parent says no once they are contacted, it is always up to us to decide to walk away or not walk away. That is already true, and there is no protection right now for search and reunion for adult adopted persons who choose to engage in that, or for birth parents who choose to engage in that. Because in today's age of the internet and of DNA testing, this bill is not about search and reunion. It's about an equal access to the government's verification of someone's birth, that we are a subset of citizens in the Commonwealth who are not allowed access to that document. Documents are not owned by biological parents. Any of you who are parents sitting up there, you don't own your child's birth certificate. You don't get to decide if they see it or not.
Well, we understand the point, but there are issues to balance here. Senator Servo.
It's one of the questions I had. I mean, first of all, I think in terms of some of the questions and the answers is an assumption that both parents are on the birth certificate, and whether or not a father's listed, I think, is the option of the mother. And so,
Correct.
and the mother can put down whatever name she wants. I think there's no testing or anything required to show it's actually the real father or whatever. But given the fact this law has been on the books since 1976, I would assume that a lot of people who were in this situation were thinking about whether or not this document was accessible when they decided to put somebody's name on it or not put it on it, because they were assuming that it was going to be sealed forever. And so how many states have had a situation where records were sealed, then they changed the law and just made open access to things that when people created them thought were going to be sealed forever? Because I think there's also a question of whether you retroactively unseal things or whether you only do it prospectively. How have other states approached that problem? Do you know?
I do know. So Alabama was one of the first states to make this change. That was 24 years ago that they made that change. They have had no issues of any birth parent coming forward and claiming some concern with the state having released an original birth certificate. All the other states that I've previously talked about, the 13, 14 other states, are not seeing any difficulties with the concern that you have. And if I could speak for a moment as a birth parent who has had to make this decision, I assure you the decision of whether my son's birth certificate was going to be sealed or not was not up to me. Nobody asked me if I wanted that. That was what I was told would happen. I didn't want him to not have access to his original birth certificate. My issue of privacy was I was 15 years old. I did not need the general public to know that I was making this decision. I did not need to be protected from my son, and I don't need to be protected from my birth mother. That is not what this is about. This is about being able to have equal access to the government's verification of birth that we are denied as adult adopted persons in the Commonwealth.
Okay,
Madam
thank
Chair.
you. We're not taking comments or opinions just yet.
Madam Chair.
Let's keep this to facts.
Yeah.
Okay, Senator Jordan.
Thank you, Madam Chair. So I'm adopted, so I have a question, and this is very specific. Are you aware that if someone gives birth in the Commonwealth, there is no paternity test that happens in the hospital, so therefore someone could list a father that is not in fact the father? Are you aware of that?
I am aware of that as my
Follow-up question, Madam Chair.
Okay, Senator Jordan.
Thank you, Madam Chair. To that end, that does not change, so that birth certificate will sit 18 years later when that may be opened by this person through this option that may list a person erroneously that may not be the father of a child, which may cause a host of other problems since there's no paternal test at a hospital when a birth certificate is filled out. So you're aware of that.
May I offer a fuller answer to that original question?
Madam Chair, go through the
Madam
chair.
Chair, may I provide a fuller answer to her original question?
Yes.
Because I do work in the realm of adoption and I am frequently at hospitals when children are born, my understanding from hospital staff, as I've watched them take the information down for the original birth certificate, is if the father who is unmarried to the mother is not standing right there giving his agreement to be on that birth certificate, it is left blank. So you are correct, there is no paternity testing happening in hospitals, but they are also not allowing women to put a man's name if he's not standing there giving his permission to have his name put on that certificate.
Madam Chair.
Yes, Jordan.
I'm just going to make a comment to the bill briefly to refute that. Madam Chair, we live in a state that has a ton of military installations, and more often than not, we often have families that are on deployment when birth certificates are filled out. So therefore, this happens probably overwhelmingly in places like Virginia, Florida, and California, where people are added to birth certificates without the father being present because that's common practice, just to make you aware. Thank you, Madam Chair.
Thank you. Delegate Walker, do you have anything further you'd like to add before I take public comment, which I will limit to 5 minutes? I need to say. Oh, my mistake. Yes, Senator Head.
Yeah, Madam Chair, I had several questions for the witness here. So just this is a realm that I don't know, so I'm asking some questions, but some information that I have been given, and I want to make sure that I'm clear on all of this. First of all, just to clarify what you said in difference, and I understand what my colleague Senator Jordan just said about deployment and that sort of thing, but your summation, and Madam Chair, I will have several questions if that's okay.
Sure.
The first question is your understanding is that the situation is that even if there is a deployment, unless that birth mother is married to the father needs to be present in the room for the name to be added to the birth certificate. Is that what you?
That is what I have witnessed as I have been in hospitals with women who are making this decision and needing to fill out the original birth certificate information.
Okay, so it would be nice to be able to verify that, but that's the first question. The second question is there any circumstance today under which the birth mother is able to make the decision to have the birth certificate sealed?
There is not.
And so, Madam Chair, the current situation is that the birth parents have no say into whether or not the birth certificate is sealed, and that decision is made then by whom?
That is correct. Birth parents have no say in the sealing of a birth certificate. The sealing of a birth certificate only occurs once an adoption is finalized, which is many, many, many months later, and only if the adoptive family applies for an amended birth certificate. The state registrar is here today who could probably fully answer that, but only when an amended birth certificate is created does it seal the original birth certificate.
And Madam Chair, one final question here. And so in the event that a child is born and put up for adoption, but then is never adopted, and that's a tragic situation, but it does occasionally happen. If that does happen, is there ever a situation in which those records are sealed?
There is not. And as a matter of fact, if an adoption never occurs, even after a biological parent has terminated their rights voluntarily or involuntarily, the original birth certificate remains the only birth certificate that that person has access to.
And it has all the information that
Correct.
was there. Okay, thank you.
Correct.
Let me add a clarification, and Mr. May, correct me if I misspeak, but my understanding is that an adult adoptee can get access to their birth certificate, although biological parents' names are redacted. They do have information that's related to their health. You know, whatever tests were taken, whatever information shows up on the birth certificate, other than the biological parents' names, they do have access to. Is that correct?
Madam Chair, the current process that an adult adoptee has access to is to file a court order and try to prove good cause to a judge before they can have access to their original birth certificate.
I understand your
Medical
answer.
information is not shared via the state registrar original birth certificate process.
Let me ask our general counsel. The question was directed to Mr. May.
Oh, I'm sorry.
Madam Chair. Yeah, so there's two different issues in that question. One is, no, you would not get access to your original birth certificate redacted. You would get access to a new birth certificate that they have issued. The second part about the medical information, that would be things that would likely be included in what the code refers to as your adoption record, which is held by the Department of Social Services. You basically have to file a petition with the Commissioner of Social Services to get access to that information. As an adult, you would be entitled to get non-identifying information from that adoption record, which is what, Madam Chair, you were speaking of, maybe some things that would be helpful to know of for medical reasons, but you would not be able to get identifying information unless the commissioner has found that you've met the good cause standard, which, to my understanding, is hardly ever met.
So there is a way to get access to health information, I guess is at the end of the day. I'm going to take public comment unless, I'm sorry, Senator Van Valkenburg and then Senator Salim.
Thank you, Madam Chair. Madam
Colleagues,
Chair,
please put yourself in the queue so I can see.
my question is more about context because we're talking about, Senator Serval's questions were about what are states doing right now. We've had some debates about the kind of intricacies of this. I would love to know why the law changed in 1976. I would love the context of that decision because I think that would be helpful for kind of creating a baseline of the conversation about what we're even talking about, because I'm very conflicted about this bill, but understanding why they made that decision, I think, is maybe helpful. And so maybe that's for counsel, maybe that's for Delegate Walker. I don't think it's for the advocates, no offense.
Delegate Walker, do you have a response?
Yes, Madam Chair. If she could respond to that, I think she has more knowledge of that than I do. And we also have the Office of Records here from the Commonwealth of Virginia that could answer, Senator, if you're comfortable with the questions on the father. He's also here to testify as well, Madam.
Well, let me first turn to General Counsel and then.
Madam Chair, I will be honest, I am not sure. I was not born at that time.
Let the record reflect that's the first time I've heard that answer from David May.
I do know the answer.
Madam Chair, my name is Seth Austin. I'm the State Registrar for the Office of Vital Records. And if it's helpful, I can clarify a little bit about the question that Senator Jordan had and Senator Head had about adding a father to a birth certificate. So in Virginia, the law is that if you're married at any point 10 months prior to the birth of the child, that spouse is automatically named as the father on the birth certificate. Outside of that situation, it does require what's called an acknowledgement of paternity, which can be completed in the hospital if the father is there and signs it. Can also be completed after the fact. But outside of being married, there's no mechanism to automatically add a father.
Senator Van Valkenburg, would you repeat your question about the context? I think that was.
Yeah, Madam Chair, I just don't, my some of my discomfort is not understanding the baseline upon which we're acting, right? And the baseline is that in 1976, we as a state made a conscious decision to change, and I don't understand why we made that decision, but I feel a little bit of anxiety around the state forcing people to do this, and I don't know if that's the right anxiety to have, but I'd love to know why we changed the law, because I think that that would be very helpful for people who are on the fence.
And it could have been related to culture or attitudes, so that's right.
Indeed. Madam Chair, I would only be speculating if I
Yeah,
answered
I understand.
that. I don't know the answer.
I understand. Senator Salim.
Thank you, Madam Chair, and this is specifically for Delegate Walker. And as we heard a lot of the comments up here, no one kind of raised the question around privacy. There were reason parents are making sure that their children get adopted with the confidentiality that the agencies that they go through are going to keep that information, along with government agencies, making sure that restricted access to birth certificate where the names are redacted are in that state. Do you see any unintended consequences with this specific bill where you could potentially see adopted, parents who may get contacted could potentially take legal actions?
I'm not quite, excuse me, Madam Chair. If I may.
Go ahead.
I'm not sure quite how to answer that specifically. All I know is I have the experts here. We're just trying to make available the birth certificates at a point of legal age here. Whether the implications of anything else beyond that, Senator, I do not have that answer I can provide at this point. If that's the question, I understand.
Yes, colleagues, I'm going to take very brief testimony, and I'm going to limit it to 3 minutes because we've had quite a conversation. 3 minutes total, and then we're going to have a motion. So for those who are present and in favor of this, please come forward.
I did plan to testify. Is that okay for me to go ahead and do that, even though I've already been up here?
I think you've had enough airtime. Thank you.
Okay.
We'll hear from others.
Yeah.
Madam Chair, members of the committee, thank you for the opportunity to speak with you today. My name is Jamie Weiss. However, I was born as Hope Marie in Norfolk, Virginia in 1979. I was surrendered for adoption and finalized 6 months later. My birth mother did not have the choice to seal my birth certificate, as no birth parent has at any time, not now, in the past. That does not exist under the law. It is a common misconception, but it's simply just not true. What led us to this situation of sealing birth certificates really began with a lady named Georgia Tan. I don't know if any of you have ever heard of her. I know we spoke with some people yesterday who had, but she was a terrible woman who stole children and sold them, actually murdered many of them. Some of you may have read books about her and heard about her. This is what began the sealing of birth certificates, because she wanted to cover up her nefarious activities. And it led multiple states to just kind of end up following one another down this path that was horrible and discriminatory against adoptees for no reason whatsoever. Simply, this bill does only one thing. It restores the right of adoptees to their original birth certificate that has the facts of their birth. There is no balancing of rights because there's no one else who is being discriminated against. There's no one else who has a loss of rights here. Only adoptees. This is a good bill with bipartisan support, and it's been vetted through the House. And I would ask for your support today, because restoring this right is essential to ensuring equality for all adult adopted persons that were born in the Commonwealth. It's time to end this 48-year injustice. And I'm asking you to vote yes with no discriminatory amendments on 550. Thank you.
Madam Chair and members of the committee, my name is Patricia Salinger. I became a birth mother when I was 17. I didn't seal the birth record. I had no say in the matter and was not informed when it happened. HB550 is about equality of access, the right of an adult adopted person to obtain the legal document verifying their birth without going through the lengthy and often humiliating process of getting a court order. I urge your support for HB 550 and allow Virginia to join 15 other states in supporting adult adopted people. Thank you.
Madam Chair and members of the committee, my name is Kelly Layton. I'm an adult adopted person and a registered voter in Arlington County. I'm asking you to vote yes on HB 550 to restore equality to adult adopted persons born in Virginia. Under the current system, adopted persons face a discriminatory policy in which we are denied our original birth certificates. Virginia citizens who are adopted should not be denied the factual record of their birth when all other Virginians can easily access theirs. The current system makes adoptees into second-class citizens by denying us the right to access our own record of our birth. No parent should have jurisdiction over their child's birth certificate. The record of a person's birth should belong to them and them alone. I'm asking you to stand up for equality and vote yes on HB 550.
Senator Servo? Delegate
One
Walker.
last comment, Madam Chair. Senator Sorver, I apologize. I didn't read far enough down in my notes when you asked the question about how many other states, so I just want to clear the record. I apologize for not being thorough there in that report. I mean, other than that, I don't have any other questions, Madam Chair.
Okay. I think some of the concerns have already been aired, so we don't have to hear an opposition argument. I think we've heard it. Senator Servo.
Yeah, Madam Chair, so I've just been poking around while we're doing up here, and I found a law review article from 1994, Golden Gate University Law Review, entitled "The Sealed Adoption Records Controversy: Breaking Down the Walls of Secrecy." And at least in this article, it says this trend began in the 1940s, and it was mainly motivated by societal attitudes towards illegitimate children, illegitimate motherhood, or single motherhood, I guess, was the original motivation. I don't know why Virginia did it in 1976, but it's probably about a 50, 60-page article which delves into the complexities of this, which it's very complicated. It talks about different standards different state uses versus consent versus good cause. Some states have a pre-consent statute. It talks about the balancing of the rights of the parents versus the rights of the child and all this stuff. And there's a lot of different issues to balance in this. It's not quite as sort of a unitary choice as I think y'all have made it out to be. I appreciate the view that the child's rights are supreme to the parents. I'm not sure that we have to evaluate it quite that way. But Madam Chair, this just strikes me as a very complicated issue. There's some merit to it. But there's also ways to put our toes in the water to wade into it instead of going 100% all at once. It just seems to me this ought to be studied a little bit more before we try to make a decision on it. So I would move to carry this over to the 2025 session.
Thank you for the motion. And I do want to say, for those who have taken the time to testify, for Delegate Walker and others, this doesn't mean that we are opposed to this idea. This means we're not comfortable yet with the way this bill is presented. There are other ways that we can get to this place. The Louisiana option of sort of a contact preference is something we will look at. If you choose to bring this back next year with a more balanced approach, I think you would find a more welcoming committee. So let me just say that the need for this and the voices before us were heard. Senator Servo's point about it being a complex topic is also very valid. So at this point, we don't have time to make amendments or fix the bill. We're 7 days out from our conclusion, and I believe that continuing this bill is the right motion.
Thank you, Madam Chair and committee members.
Thank you. I did get a second. Will the clerk please open the roll?
Ayes 8, no 6.
Thank you.